Am I audible?
Yes, sir.
Yes, sir.
Dear students, we have today Avinash Amarnath, who is a Supreme Court advocate and is a legal counsel at Chandhiok and Mahajan, where he handles competition law as well as litigation matters. He has previously worked with Amarchand and Mangaldas, Talwar, Thakore and Associates, and in chambers of Mr. Amit Sibal. Avinash, Mr. Amit Sibal is relative of Kapil Sibal.
His son, yes.
His son, yeah. So who has worked with Amit Sibal. And he has also pursued LLM in competition law before King's College, London. And he was also my classmate in Symbiosis Law School. And his nickname used to be Nerd because he used to top through all the semesters and he was the topper of a batch. And we welcome Avinash Amarnath with a very warm heart. And we would like to hand over the stage to Avinash. Thank you, Avinash, for giving us an opportunity to know about competition law, and which is very new to students. And many students have no idea because competition law does not come under any academics. It is not taught in many law schools as such, but on a higher corporate area, competition law plays a much important role. So in my opinion, so Avinash, you can start. Thank you.
Thank you so much, Abhilash. Great to connect with you again and your students. And thank you everyone for this opportunity. And I understand that most of the students here are in the 3-year course. So you are already professionals, chartered accountants, other degree holders, etc. So I'll obviously try to tailor my. I'm sorry. I think somebody is speaking. Is there?
Yes, I will mute all. Yeah.
Sure, no problem. So.
Sorry, I muted you. You can unmute yourself, Avinash.
Am I audible now?
Yeah.
Okay, great. So I'll try and tailor our talk towards you guys. So we have only 1 hour, and unfortunately, this topic is so vast that we can't really cover it in 1 hour. But what we'll try and do is I'll try and do 3 things. I'll try and give you, number 1, a very brief overview of the law. Second, I will tell you what makes competition law unique and different from other areas of the law. And thirdly, we'll briefly discuss what are the different career opportunities that one can pursue in competition law. I usually try to keep these sessions interactive. So what I'll do is I will speak for the first 45 minutes. And Abhilash, if it's okay, I think the last 15 minutes we can take questions from the students.
Yes, please. Okay.
No, I thought that's how I'll do it. So let's start off with what is competition law. I'll tell you, there is a big misconception about what this law is with most people. And whenever I tell people I practice competition law, the first thing that people ask me is, does it have to do with the UPSC competitive exams, which it doesn't. I've been asked by some people, does it regulate sports competitions and lotteries, etc.? Again, it doesn't. So these are very common misconceptions. So to explain what exactly competition law is, let's take a real life example, because I think that's the best way to understand it. So I don't know, I think many of you, I don't know if people are my age or people here are younger than us, but there was a time back in around 20 years back when mobile phones were very, very new. And at that time, you had only one network operator, which was, of course, BSNL. Now, if at that stage when BSNL was the only operator and mobiles were introduced, I know it sounds incredible now, but there were actually even incoming calls used to be charged. Outgoing calls would be almost 8 rupees or 10 rupees per minute. So the price was compared to today was enormous. Now, slowly what happened was they privatized the sector. New players started coming in. First, of course, was the precursor of Airtel. I think it was called D, something starting with a D, I forget. So that was the first player that came in, and the prices came down a little bit. Then, of course, we know after Airtel, Hutch came in, Idea came in, Vodafone. So many new players entered the market, and prices started falling. So first incoming became free, then outgoing charges started getting reduced. And then, of course, most recently, I'm sure all of you are aware, when Jio entered the market, the prices dropped so drastically. Jio, in fact, had offered it free, had offered all their services free for the first 6 months. The other players, because they had to retain their customers, were also forced to drop their prices. Now, this is what we mean when we say competition. It is the process of competition in the market. And why is that good for us? It's good for us because it reduces the price of the products, it increases the quality of the product, innovation. It is good for society as a whole. It increases efficiency, it increases consumer welfare. So that is why competition is good. That is why most economies now allow private participation and allow multiple players to operate in the market, because that process of competition leads to welfare. Now let's take a counterfactual scenario. Imagine what would have happened in this example that I gave you. Let's say when Jio entered the market, instead of doing what it did, which was to offer the services free for the first 6 months, if Jio, Airtel, Vodafone, and Idea had sat in a room and said, look, we don't want to undercut each other. Why should one suffer at the hands of the other? Let us all make profits. So let us do one thing, let us divide the market. So Airtel, you focus on the north, we will not compete there with you. Jio, you focus on the west, Vodafone on the south, Idea in the east. Just hypothetical example. Now, if such an agreement had been reached, Jio would have never offered those services for free, because it didn't have to, because it was assured that customers would be there. It had a territory allocated to it. So who are the ultimate losers then? The ultimate losers would be us, the consumers, because we would not benefit from competition. We would not have reduced prices. We would not have better quality products, etc. So competition law is precisely aimed at preventing practices like this, which affect free and fair competition. It's not anti-business, it's actually pro-business. It encourages competition in the market. And it is a law that is aimed at protecting the process of competition. And the reason for protecting that process is because it benefits consumers. So this is broadly what competition law is about. It's a very economics and market-based law. So, and I'll come to this later when I talk about what makes competition law unique. But I would say that a basic understanding of economics of how markets work is an absolute must if you have to study or practice competition law. Now, there are three broad limbs of what competition law regulates. So the first is what we just spoke about in this example. Let's say that agreement between Jio, Idea, Airtel, and Vodafone to divide markets. That is what we call cartelization in common parlance. So cartelization is any agreement between competitors to restrict the process of competition. It may be by way of fixing the prices. So instead of competing and reducing the price, they are all going to charge a higher price. It could be by way of market division, which is what we just spoke about. It could be by way of sometimes what we call bid rigging as well. So sometimes the government calls for tenders in certain markets, and the competitors beforehand itself decide who should win the bid this time, who will win the bid next time, etc. So that, and apart from that, there are certain other types of agreements between manufacturers and suppliers. We'll come to that. That's a much lesser, less serious offense. But broadly, the first limb that competition law covers is regulating anti-competitive agreements. So if a company on the market enters into such an agreement, it is a violation of the competition law, and the Competition Commission can proceed and impose a penalty on such parties, and the penalties can be quite significant. The second limb is what we call abuse of dominance. So here again, just to give you a very simple example, in India, the Indian Railways is a monopoly. So if you have to take trains, the only train operator is the Indian Railways. It's a government entity. So it is a monopoly. Now, being a monopoly itself is not prohibited under the law. But if Indian Railways tomorrow suddenly decided to increase the price by 200%, then such actions could constitute what we call abuse of dominance. So that means you have a strong position in the market because you're the only player, and you are misusing that position to exploit customers or to prevent competition from entering. So let's say, for example, tomorrow the government actually decided, and this is something that has been in discussion, that the government decides to privatize certain routes of the railways. Now, what happens is that, let's say, for example, to give you a simple example, let's say that the Delhi-Jaipur route has been privatized. So private trains can now operate between Delhi and Jaipur. But the stations are still owned by the Indian Railways. So if the Indian Railways decides that, no, I will not allocate platform space to the private trains, that is an abuse of dominance because you are preventing competition from entering the market. And you are doing that to benefit yourself. So things like that are called abuse of dominance. That is the second limb that competition law prohibits. The third limb that competition law regulates is what we call merger control. Now, it's very common in the market for takeovers and acquisitions to happen. So it happens for a variety of reasons. Most of them are legitimate. So one company, for example, most recently, going back to the telecom example, Vodafone and Idea merged, and now they are called Vi. It's a new entity. It resulted out of a merger of Vodafone and Idea. And it's done for various reasons. You are not, you think that there is a scope for your business to expand by taking over another company. You think that they have certain strategic assets which might help you in your business. So there are various reasons. So again, merging itself is not illegal. However, when such a merger has an adverse effect on competition, then what the competition authorities or competition law does is to first ask the parties to notify the authority before they go ahead with the merger. So you'll have to file a notice in a sense. And then the authority will review what is the position of the parties on the market. And if it feels that there is no impact, it will approve the transaction, and then the parties can go ahead and merge. So to give you a simple example of this, for cool drinks right now in India and most countries in the world, we have only two options. We have Pepsi, we have Coca-Cola. Now, nobody denies that they compete vigorously with each other, which is why it's good for us. But tomorrow, if let's say Pepsi and Coke decided that we will merge, then there will be only one soft drink provider in the country. And then they could act independently, they could raise prices, they could reduce the quality of the product. So therefore, in such a case, the competition law says, wait, before you go ahead with a merger, you please notify us. We will review and decide whether this merger is impacting competition. If it doesn't, we'll approve it. Otherwise, we have the power to block it. So that is the third broad limb that competition law covers. Now, the competition laws are at the moment there in almost 140 countries in the world. And this number is going up every day, because world over there is a recognition that this is a very, very necessary law, because there has to be free and fair competition in the market for the country to advance and develop. And most of them will be along the same lines as we discussed earlier. Almost all of them will have these three limbs that we discussed just now. So coming to India, in India, when did the competition law start, and how is it panned out over the last few years? So way back in 1970, we actually had an earlier version of the competition law called the Monopolies and Restrictive Trade Practices Act, MRTP Act, as it was called. Now, it was felt that now around 98, 99, 2000, also in between, I should mention, so I don't know if most of you know, but in 91, India, there was a mini revolution of sorts, I can say, that India changed its entire system of economy. So up to 91, we had what we called a command and control economy, where there was a lot of government control over private enterprises, over businesses. Many of them were actually publicly owned, meaning that the government had taken them over. Now, around 91, we faced a huge debt crisis. And as some of you may know, Manmohan Singh at that time, the finance minister, introduced what we call the 91 reforms, which was to liberalize, privatize, and globalize the economy. So they freed up restrictions. They allowed more private players to enter, foreign players to enter the market. And that, of course, has produced tangible benefits for us. So as part of that change, it was felt that the earlier MRTP law focused more on size of the enterprise and not the conduct. So being big itself is not bad. We have seen that with economic experience. It is only when you abuse that position or misuse that power is it a problem. So it was felt that the earlier MRTP law was focusing more on size because it had restrictions on how much turnover a company can achieve, how much shareholding a company can have, etc. So rather than focusing on the size, it was felt that a new law is necessary, which focuses on the economic conduct of a company or of a business on the market. So that is when the Competition Act of 2002 was enacted in India. It was a brand new law. It established a body called the Competition Commission of India, CCI, to enforce this competition law. The CCI is the only body, it has exclusive jurisdiction to enforce competition law. So regular civil courts cannot enforce competition law. It is only the CCI that has the jurisdiction as per the Competition Act. The provisions, the substantive provisions of the law came into force in around 2009. And since then, we have had around, I would say now, 12 years of enforcement of competition law. So what is the procedure under competition law? What happens in a case? So let's say that so the first and the most important thing is that in competition law, there is no strict requirement of a locus standi. So it is almost like a public interest litigation, which I'm sure you would have read about while you're doing constitutional law, etc. So in a public interest litigation, what happens is anybody, even though they don't have a personal interest in the matter, can approach the court and bring to the court's attention issues which are in public interest. So similarly, in competition law, anybody, even a third person who notices any anti-competitive conduct, can approach the CCI with what we call an information. We don't call it a complaint because he's not a complainant in the strict sense. He's simply an informant. So when an information is filed, the CCI first reviews that information and sees whether prima facie, that is preliminarily, whether a case of violation of the law is made out. Now the CCI at this stage also has the suo motu power, meaning on its own also, if it notices through, let's say, even sometimes letters are written to the CCI, sometimes it notices in the newspapers some issues, let's say, which it thinks could be violative of competition law. It can also take suo motu cognizance of this matter. So based on an information or on its own discretion, the CCI will first examine whether prima facie there is a violation of the law. If it feels that there is a violation, it will pass a prima facie order directing an investigation into the matter. Now, once such an order is passed, the matter then goes to what we call the Office of the Director General. So this is a part of the CCI, but it is the investigative arm. So when the matter is referred to the Director General's office, what we in normal parlance call the DG office, the DG then conducts a full-blown investigation into this matter. So he calls for information, not just from the parties, the opposite parties, the parties who are being investigated. It also calls for information from third parties, competitors, customers, the informant also. So it will call for information. It can even record their statements on oath. It can conduct cross-examinations. So if an opposite party wants to cross-examine an informant's witness, it can do so. Based on all the evidence it collects through its investigation, the DG will then prepare a report known as the investigation report. So the investigation report will record all the facts that have been found and then will make a recommendation saying whether the law has been violated or not. Now, once the report is prepared, it is then sent back to the CCI. The CCI will then forward that report to all the parties concerned, the informant and the opposite parties. It will give them an opportunity of filing written replies, and then a final hearing is conducted. Based on that final hearing, a final order is passed, whether there is a contravention of competition law or not. Now, assuming that the CCI finds a violation, what all can it do? It can order an enterprise to cease and desist, meaning that it can order an enterprise to stop indulging in certain conduct. It can declare agreements to be void. most importantly, it can impose a penalty of up to 10% of the turnover. Now, it may seem like a small number, but for large enterprises, this is a huge sum. So most recently, to give you examples, in the cement industry, the cement companies were found to be guilty of a cartel for price fixing. And the total penalties in that case on all the companies, not just one company, but 11 companies put together was around 6,000 crores. So there are huge fines involved. Similarly, the real estate developer DLF was found to have abused its dominance. And in that case, the CCI imposed a penalty of 630 crores. This is just on one company. So the fines can be huge, the consequences are huge, and therefore companies, especially the larger ones, take competition law compliance very, very seriously. Because if they don't, the consequences are quite severe. There are even individual consequences for the managing directors and the management, because they can also be individually penalized, and they can end up being disqualified as directors. So if you are a director in a company that has been found to violate competition law, you are disqualified under the Companies Act to sit on the boards of other companies. So the consequences are very dire. Now, once an order is passed by the CCI, a final order, of course, there are opportunities of appeal. So the first appeal goes to the National Company Law Appellate Tribunal, that's the NCLAT. And from there, a second appeal goes to the Supreme Court of India. So this is the broad structure of competition law and what it covers. As I said, 1 hour is not adequate to do justice. So I've just given you a very, very brief idea. We'll, of course, if time permitting and depending on questions, we'll try and go into a little more detail. Now, coming to the second aspect, which I wanted to talk to you about, which is what makes competition law so unique. Now, this is what attracted me to competition law. Some of you may not be. Actually, I know that some people, the things that I'm going to say right now are the reasons why some people don't like competition law. So it's a very individual based choice. But for me, what made competition law unique and attractive was, number one, the fact that it was an economic law. I was a student of commerce in my +2. I had economics as a subject, and even when I was doing my BA LLB in Symbiosis, we had economics in the first year. So I have always been interested in economics, and as I had said, how markets work, how business strategies work, that's what competition law is all about. So if you are interested in that sort of thing, if you're really interested in business strategies, how companies work, how the process of competition works in the market, economics, competition law is definitely the subject for you, because it is essentially an economic law. The second thing that attracted me to competition law was, unlike many other laws, which are very, very, I would say, rule-based and technical. So, for example, the CPC, of course, it's a procedural law, but the CPC has around 160 sections and around 20 plus schedules. Whereas if you look at the Competition Act, while it does have around 60 odd sections, the substantive law is contained in just 3 sections. So it's a very, very wide-based and flexible law, because as I said, because it is all about market behavior. You cannot legislate or put down in rules every type of conduct that can contravene competition law. So what the lawmakers do is they have put down a very widely worded law, which has the capacity to catch several different types of conduct. And we are seeing that most recently, and the benefit of this is also has been seen most recently, because the way business is done has changed dramatically over the last 5-6 years with the introduction of the internet. So just to give you a simple example, the Ubers, the Swiggies, and the Zomatos of the world. So their business used to be conducted mostly on an asset-based model. So just to give you an example, in the taxis, for example, Meru, which was the prevalent taxi operator before Uber and Ola came into the market, they owned their taxis. The drivers were their employees. They paid them salaries and they operated the taxis. Whereas Uber and Ola came in, used the internet, used the technology that was available to them and said, look, we don't have to own the assets. We will simply be aggregators. We will connect people who own cabs with consumers who want to use those cabs. And we will create an asset pool that is much, much larger than an asset-based model could ever produce. Now, having said this, so therefore, competition law as it stands even now, and this was a law, in India, it was enacted in 2002. In the US, it was enacted 100 years back. But still that law is it has enough flexibility, and it is widely worded to catch conduct of Uber and Ola as well. That's what makes this law very, very interesting, according to me, because new business models, new strategies keep coming up. And we as competition lawyers have to think about how the law will apply to these new scenarios. So that is, again, something that's very unique in competition law. And the third and the last thing is, of course, that it's a very open-ended and flexible law. So it gives you a lot of play to interpret the facts, to play around with the facts. It's something that's I find very interesting. So you're not restricted in a sense. You are free to make a lot of innovative and open-ended arguments. So competition law, so as I said, these are, if economics, if the way markets work are something that you find interesting, then competition law is definitely that you must look into. Now let's look at the last question, which is, what are the careers that are available to you as students, as law students in competition law? So the first and the most obvious one is, of course, to practice competition law as a lawyer. Several law firms have large competition teams. Usually competition law, due to the nature of the work involved, it's very, very fact intensive. It requires a lot of work, a lot of dedication. Just one case can sometimes take up many years of your life. So because of that, generally law firms tend to have large competition law teams. Of course, there are individual lawyers as well who practice competition law, but that's much fewer in number. So one option is obviously to try and get into a law firm as an associate in their competition team. And to do this as students, you can first apply for internships in these law firms. Once you start doing these internships, many of these law firms will use that as an assessment and see if you are good enough, and then may be willing to hire you. The second avenue to practice competition law would also, of course, to join an arguing or a senior counsel who does competition matters. Now, in these scenarios, it would be not restricted just to competition law, because most arguing senior counsels don't restrict themselves to one area of law. But there are some seniors who focus a lot on competition law. So if you find those senior counsels and you join their chambers, you'll again be able to pursue competition law there. The third option, and this I believe, as Abhilash was telling me earlier, a lot of you are company secretaries, chartered accountants. So for you, having this knowledge of competition law also helps in securing an in-house legal position. Because as I was saying, companies, it is becoming increasingly important for companies to be aware of competition law. So they actually want in-house specialists who can assist them on competition law. They don't always go to external law firms. So if you want to become an in-house lawyer, a general counsel, etc., and if you already have the knowledge of being a company secretary and a chartered accountant, this knowledge of competition law will definitely aid you, or will be a definite addition to your CV, let's say, to take up an in-house position. The fourth area where you can, again, explore is the regulator itself. So unlike certain other areas of law, in competition law, it's a very flexible policy. Lawyers sometimes go and work at the CCI, which is the regulator, and they hire experts from outside because they also need the expertise. As I said, it's a very time-consuming job. So the CCI has a huge staff. It's still understaffed. They need a lot more people. The DG office as well. And it gives you a very good perspective, because if you are on the other side, on the regulator's side, you get to think, because sometimes as a lawyer, all you're thinking about is your client, your facts, and how you can, escape or, let's say, prove your case. But when you work with the regulator, you get a much wider, broader perspective, because they look at things more from a policy perspective, because they are the regulator. How will the whole law be established? What are the principles that we must adopt in the law? So that is again a very good area to explore. And the last option, of course, is a very important option, I would say, and something that you shouldn't ignore is teaching. As Abhilash said just now when we were discussing, competition law is hardly taught in any of the law schools right now, despite it being quite an established law with a lot of scope. Many law schools still don't have that as a course, and that's also because there is a shortage of academia on the subject. It's difficult to get teachers who can teach competition law effectively. So that's again a definite, a very important career opportunity that you can consider. So having said all of this, let me just add a few more things because we do have some time left.
Is there a state body, Avinash, like a competition commission established for individual states in our country?
No, Abhilash. So this is only a all India based. So it's a central legislation. So there's only one competition commission, but they have the power to establish regional offices. So in fact, most recently, the CCI opened up a branch office in Chennai. It is based in New Delhi, but so yes, I think there has been a call from many lawyers that, they should have more branches across the country, because I can understand, I'm also from Bangalore. But I've been living and working in Delhi for the past 8 years because the CCI is in Delhi.
So can you share your experience? You worked with Competition Law Commission or you interned there, right? Once.
Yes. Okay, so yeah, I think what I'll do now is I'll just take you through my journey as a competition lawyer, so that maybe that might also help you guys a little bit. So when I was studying in law school with Abhilash, competition law was even newer. So at least now, I'll say that 5 or 6 colleges teach competition law. At that time, not a single college did. So I got attracted to the law because I was doing a moot court competition where one problem was relating to competition law. So that sort of triggered my interest. After that, I searched for opportunities to see how can I explore this interest further. And one opportunity that came about then was an internship with the CCI itself. At that time, they were still just setting up office. So there wasn't too much actual enforcement work, but it was a research-based internship. So I spent 1 month researching on a particular topic. I prepared a research paper, a presentation. I presented to the members of the commission. I don't know if that's a practice they still follow in an internship, but it was a very enriching experience because as a law student, to be able to interact with the members of the CCI at that stage was a really good learning experience for me. Pursuant to that, I then started internships with a few law firms who deal in competition law in my 5th year of law school. After that, because at that time competition law was not taught in India, I decided that the best way for me would be to first get a degree in competition law. So for that, I had to go outside, do an LLM in King's College London with a specialization in competition law. And after that, I came back to India. I joined the competition law team of Amarchand and Mangaldas. I was there for 1.5 years. Then I joined another firm called TTA, Talwar, Thakore and Associates. I was there for around 4.5 years. And after that, of course, I moved to Mr. Amit Sibal's chambers. Mr. Amit Sibal is one of those senior advocates, as I was mentioning earlier, who does a lot of competition law. But because my interest was also then to expand a little more out of competition law, I joined his chambers, started doing other types of litigation work as well. And of course, after that, now I'm here at Chandhiok and Mahajan. Now, just a few more things that I thought, since we have 10 more minutes, let me just speak a little bit more about the law, more in terms of practical aspects as to what all a lawyer is required to do while he practices competition law. So clients, there are 2 types of clients broadly. You will have clients who are the informants. So they will come to you saying, we want to file a case against XYZ. Then there are the opposite parties where you are more like a defense counsel. You are defending them against allegations. If you are an informant counsel, then the first thing for you to do will be to draft an information. So there are no, it's not that there is a very strict format, but there are regulations as to how an information should be drafted, what all it should contain. Broadly, you need to make sure that you are stating all the relevant facts. You are explaining how there is a violation of the competition law. And most importantly, you are producing some evidence to show that there has been a violation. It's critical this. Very often we have clients who will come to us and say, look, we know something is happening and we want to file a complaint, but because we live in a rule-based, evidence-based system, we have to get at least some evidence of that. So that's very important. Of course, at the prima facie stage, the CCI also doesn't expect you to give detailed evidence, but at least some evidence you have to show that a violation has taken place. So once you have filed that information as a lawyer, the CCI has the discretion. At the preliminary stage, it need not call you for a hearing. They're not obligated to call you for a hearing, but they may. So if they do call you for a hearing, you'll get a oral hearing at the preliminary stage itself. Now at that stage, again, as a lawyer, you have to think about, depending on your client's appetite, their financial, their willingness to spend, whether you want to argue the matter yourself or you have to engage a senior advocate. So many of the bigger clients sometimes may prefer that they want a senior advocate to come and argue the matter. Now, if that is the case, then there is a second round of preparation, because you have to brief the senior advocate. You have to explain to him exactly what your case is, what you want to say to the commission, etc. So you'll have to send him all the files. You'll have to prepare notes for him. You'll have to pull out judgments, etc. So that is another, part of the work that happens. Then on the day of the hearing, of course, you appear or the senior advocate appears. We make oral arguments. Post those oral arguments, sometimes you do file another set of written submissions or a note. Based on that, then the CCI decides the prima facie decision. Now, let's say that the prima facie decision is taken and the matter has been sent to the DG office. Then a next round of work starts for you of coordinating with the DG office and giving them whatever information they require. Now, this is actually a very critical aspect of the work, because while it is very fact-based, meaning that they will simply ask you for certain information and you have to supply that, as a lawyer, you are expected to first see that information, see if it hurts your client or harms your client in any manner. Particularly, let's say if you are an opposite party counsel, if you are a defense counsel, it's very important to see what evidence, what fact. Of course, you can't suppress facts, you can't suppress evidence, but certainly as a lawyer, you can review the evidence to see what exactly has been asked, what has to be given, and what is not necessary, what need not be given. Then when the DG calls your client to depose on oath, to give an oral statement, again, there is some work involved. You have to have some amount of course, you cannot coach a client for an oral deposition, so you can't teach him what has to be said. But certainly you can discuss the case, you can show him the records, you can say what is the broad stance to be taken, what are the facts to be given, etc. Then there is also a cross-examination element at the DG office. At that time, again, that is again a very exciting thing. It's something that you would have seen in criminal courts as well, cross-examining the other side's witness. So there's a lot of preparation. Again, sometimes, senior advocates may come in to do the cross-examination, or sometimes you may do it yourself. And in a cross-examination, there's a lot of research, because you have to, because there are several things that you can do in a cross-examination. Apart from the merits of the case, you can also discredit the witness. So you can pull out information relating to him, information relating to his company, his various roles, etc. So again, that is a very interesting piece of work that comes about. Now, once the DG report is prepared, and is supplied to you, if it is a favorable DG report, that means it finds in your favor, then you usually don't file anything too detailed. But if it is against you, then again, you get an opportunity to file a detailed reply. Again, so you draft that reply, you file it, and then there is a final hearing where, again, the process gets repeated. Now, of course, the hearing is much more detailed. Final hearings can go on for almost, sometimes they go on for 2-3 days. Again, a senior advocate may get involved, or you may argue yourself, depending on your client's preference. And then you have the final order of the CCI. Competition law cases are generally quite time consuming. So from the stage of information to the final order before the CCI, it could take anywhere between 2 to 5 years, depending on the complexity of the case. After that, of course, there are appeals which could then take another, I would say, 4 to 5 years. So it's a long drawn process, but it's fulfilling if it's an interesting case and there's a lot of facts to look into, etc. Now there's another avenue of work that has come about most recently, which is that so when a prima facie order is passed by the CCI, such an order is not appealable. It cannot be appealed before the NCLAT. So what many companies do is, if they feel that that prima facie order was unfair, let's say they were not given an opportunity of hearing, or that the informant maybe produced some false facts, etc., or there was some other violation of principles of natural justice. In such a scenario, what we have seen recently is that companies take these prima facie orders and challenge them in writ petitions before various state high courts. So in that sense, one can say that competition law is also practiced before high courts. The volume of such work is, of course, not very significant. So, some high courts, I think, till now have not seen a competition law case, whereas some high courts have. So most recently, to give you an example, in the Karnataka High Court, Amazon challenged the prima facie order that was passed by the CCI against it before the Karnataka High Court. The reason it came to the Karnataka High Court was because its registered office is here. So depending on the territorial jurisdiction of high courts, we see that sometimes writ petitions may be filed in the high courts. And then there, of course, we don't get into the merits of the competition law too much. It is mostly about administrative law, whether oral hearing, whether the hearing was given, whether the documents were supplied. We look at principles of natural justice, basically. But yes, sometimes you are required to get into the merits there as well. So this is broadly, in the limited time we have, just a broad overview of competition law and careers in competition law. And now I'm happy to take questions, Avinash.
Avinash, one question I have. On a layman's understanding,
Yes.
How does Competition Commission recognize that he has committed certain type of crime or anything like that? Can you just say some example based quoting two companies?
Yes.
Like this?
So, okay. So how does let's say the CCI decide whether there is a violation? So the first type of violation is what we call cartelization. So in that, to give you a real life example, cement companies. So what the cement companies were doing was they had a trade association called the Cement Manufacturers Association. So using that association as a platform, they were exchanging price sensitive information, meaning what the other company was going to charge as the price. Now, because of that exchange of information, they were actually coordinating on what prices they should charge. So all of their prices would increase at the same time, would decrease at the same time. So this the CCI found was a cartel, because you are fixing the prices of the products. You are not independently competing on the market to determine what the price is, but rather you are cartelizing, you are coordinating the prices, and that is not good for the consumer. So the CCI found in such a case that this is cartelization and they imposed a penalty. Now, the second type of violation could be what we call vertical agreements. So to give you an example here, this was a case that was initiated against all the car manufacturers in India, all of them, Maruti, Tata, Hyundai, everybody was investigated. And it was found that all of them had these agreements with their spare parts suppliers, that the spare parts can only be supplied to the authorized dealers of that company. So let's say, for example, BMW insisted that the spare parts have to be sold, their spare parts have to be sold only to BMW authorized retail or authorized dealers or service centers. Now, what that was doing was that, let's say, we have these now private service centers like Carnation and a few others. Most recently, I think there's an app also called Go Mechanic, which provides services. Now, if independent service centers like this are not able to get the genuine spare parts, then they are not able to offer service of BMW cars. So the CCI again investigated and said this is what is happening because of these agreements is that independent service centers are getting thrown out of business. It is affecting competition. Therefore, they found that that was a violation of the law, again imposed a penalty, and actually asked the companies that you cannot enter into such an agreement. Spare parts, genuine spare parts must be available freely in the open market. Anybody should be able to go and procure those spare parts, whether it's a customer or it is an independent service center. So that's a second type that we call vertical agreements. The third type of violation is what we call abuse of dominance. So here a classic example was what I had mentioned earlier, DLF. So DLF is a real estate operator, as we all know. It has a huge land bank in Gurgaon in Delhi, and a lot of the Gurgaon land is actually owned by DLF, and they have lots of projects developed there. So the CCI investigated and found that they were a dominant player in Gurgaon for apartments, high-end apartments specifically. And they found that what they were doing was they were imposing very, very unfair, one-sided terms and conditions on the flat buyers. So they could so DLF, even after they entered into the agreement and collected the money, excuse me, DLF could unilaterally change the floor plan, the areas allocated to the common areas. So several such, one-sided and unfair terms and conditions were found. And the CCI found that this is an abuse of dominance and imposed a penalty. Of course, this was before the RERA came into effect, the Real Estate Regulation Act. So at that time, there was no regulator for the real estate. So the CCI took upon itself this mantle. But it is a classic example of abuse of dominance. So broadly, these are the different types of, conducts that the CCI can investigate and find to be a violation of the law.
Any questions? Yeah, that's really interesting to know how CCI recognizes violations.
Yes.
Hi. This question is related to jurisdiction. You said
Yes.
we have RERA and all. What about
Yes.
other regulators like TRAI, SEBI, or ILTA? How does it gel with the CCI?
Very good question, Pankaj. So I didn't get into that much detail because I thought we had less time. But now that you asked the question, I will get into it. You are right. There are other sector regulators which regulate their particular sectors, and therefore, sometimes there may be an overlap between these sectors. So there was a judgment of the Supreme Court where the Supreme Court looked at the conflict between TRAI, as you mentioned, and CCI, and said that when there is a matter which falls exclusively within the domain of TRAI, then TRAI will first look into it, then the CCI will, only once the TRAI has determined that matter, then the CCI has jurisdiction. So when there is a conflict, the sector regulator gets first preference. After that, the CCI can investigate once the sector regulator has determined the facts.
Sir, I'm Subhash here.
Yes.
Sir, even we find the facts and court given some of the verdicts also.
Yes.
Again, same problems will arise in the government. How it can be regulated, sir?
Yes. So you mean to say that the same facts are determined by the CCI?
Yeah.
And the same facts again come up before the courts?
Yeah.
So in that scenario, there are two things here. One is that there is sometimes what we call concurrent jurisdiction, meaning that the same facts can give rise to violations of two different laws. So to give you an example here, for example, when there is it's not competition law related, but let's say, when there is a check bounce case, it gives rise to both criminal liability as well as civil liability. They're two separate causes of action coming from the same facts. So if it's such a scenario, then both the proceedings can progress simultaneously. However, if it is the same subject matter relating to the same law, and a second case is brought, then it would be hit by what we call the principle of res judicata, which means that once it has already been determined, it cannot be reopened again. So, the other side can actually argue that this has already been determined, it has attained finality. The principle of res judicata should apply.
Thank you, sir.
Sir, this is Vipul here. As I understand, competition law in India is still developing.
Yes.
But how would you compare that with the competition law in other countries? And what do you think is the necessity or way forward of competition law in India?
Great question, Vipul. So you're absolutely right. Competition law is still in a nascent stage in India. And so broadly, I would say that actually the two oldest systems of competition law in the world are the US system and the European system, the European Commission. And most of the other countries have followed or, been inspired by these two systems of law. Now, where I see us lagging and we need to take it forward a little more is that these two jurisdictions have now become so mature that they take a lot of economic analysis into account, because they realize that competition law is all about markets, it's all about analysis. So they have a very economics and effects based approach. So they actually look at whether this conduct has had an impact on the market. There are various statistics used. In India, we still don't see that. The economic approach is still not very prevalent. We tend to go simply by the letter of the law, letter of the agreement. So that analysis of the actual impact on the market, the effect on the market is still not there. And that's something that has to be brought up. We also, of course, we need expertise in that field. I believe we don't have enough economic experts in the CCI, which is a necessity, because any competition authority anywhere in the world, especially the mature ones like US and Europe, have both lawyers and economists as their staff. So there is a good interaction of both. Whereas in India, I think we are lacking on the economics side.
So one question I have, Avinash.
Yes,
because Geo declared, like if we see in the past, they declared free data and phone calls for 6 months.
Yes.
Can it be held as a violation in Competition Commission?
It could be. So yes, in fact, there was actually a case brought against Geo for what we call predatory pricing. Now, what is predatory pricing? Predatory pricing is when there is a dominant player who, just to drive out competition in the market, puts its prices so low that the competition is not able to compete. So because you are a dominant player, you have the finances, you can take that loss. So you will make it free. The competitors are not able to do that because they don't have the same financial resources as you. They get driven out of the market, and then you can raise the price to whatever you want. That is what is predatory pricing. So this kind of allegation was made against Geo. But the reason Geo was exonerated was that Geo was a new entrant. So predatory pricing is unlawful only if it is done by a dominant player. And a dominant player is somebody who is well entrenched in the market, who has the largest market share. He's he's the biggest player on the market. He has economic power, etc. Now I know that you'll say, oh, but it is Reliance. So Reliance is anyway huge. But in competition law, when we say dominance, we look at dominance in what we call the relevant market, meaning the market on which the conduct is taking place. So in this case, the market would only be the telecom service operators. So in that market, Geo was a new entrant. So therefore, the CCI looked at the case, but said because they are a new entrant and it is for a limited period of time, it was only for 6 months, we don't find it to be unlawful.
Okay, interesting.
Yeah.
So where is this cases from? Most probably in India.
Sorry, sir. You mean so? You mean where can we find these cases, or where do they come from, or?
No, cases from most probably in which state, but more cases are there.
All over, actually, all over India. There's not really one particular state, I would say. Mostly, but where the big businesses are. So you see a lot of cases come from Mumbai because almost all the big corporates have their offices in Mumbai.
No, in Karnataka, I'm not seeing that type of business.
Karnataka, there have been cases against, not many, you're right, not many, but there have been cases. So in fact, one of the cases I am dealing with now, interesting case, and I can tell you. So Karnataka Film Chamber of Commerce, KFCC, they were investigated and fined because I don't know if you remember, but a while ago to promote Kannada films, they had introduced certain rules that theaters can only show non-Kannada films. They can only show one show a day, and there were some other restrictions. And that was actually held to be anti-competitive because it was affecting the competition from other non-Kannada language films. Being a Kannadiga, perhaps I don't support it, but yes, as a matter of competition law, that was a violation.
Okay, thank you, sir.
Sir, I have one question. One is basically follow-up to the Abhilash question.
Yes.
So which is the first one is basically, for example, in a scenario where government is restricted not to allow some companies to India, probably of actually where I'm coming is like once upon a time Walmart is trying to come to in India.
Yes.
And under the impression that they will sweep entire the retail market in India, where the small businesses will clean, and after that they will take completely over of the Indian market, and that's where government is not allowed. In this scenario, is this CCI can pitch in, and then can they have any jurisdiction to be involved in that? And that's
Yes.
my first question. And second question is like in terms of this agreements, mostly these companies follows, as per my understanding, is like an informal agreements between them.
Correct.
They become syndicates and they decided prices themselves, and there is no clear cut agreement between them. Those most are informal, they follow it. In that scenario, how we can prove it in the CCI that these people are following it? Thank you, sir.
Great question, Satya. So first question to answer that. Yes, the CCI has some power to interfere, but that is something what we call competition policy. So when the government frames a policy and that policy itself is restricting competition, CCI cannot prevent the government, but they can certainly make recommendations. So regularly the CCI, what they do is they carry out what they call this competition assessment of various laws. So they look at a government law or a regulation and they assess whether such laws or regulations are restricting competition. If they feel that such laws are restricting competition, they can write to the government saying that we think that this law may not be in the interest of competition, but that the powers are only recommendatory in nature. They can't actually stop the government from imposing any such laws. As far as your second question is concerned, you're absolutely right. Most, especially cartels, are never going to be in black and white. They're never going to be in writing. It's always in an informal manner, as you said, as a syndicate. In fact, they actively try to cover up the evidence. They will never try to leave any evidence, which is why two things. So first is that the definition of an agreement under the Competition Act is very wide. It includes even an informal arrangement or understanding. That's number one. Now, second, as far as you said, the practical way to prove it, there are two methods that the CCI can use to do this. One is what we call circumstantial evidence. So circumstantial evidence, you will of course read this more in the Evidence Act, is evidence which is not directly proving the act, but which leads us to the conclusion of that act. So to give you a real life example, there was a cartel case where several suppliers of some aluminum phosphide tablets to the government were held to have found to have cartelized. There was no direct evidence of any meeting or any agreement, but the CCI found a few things which were very stark and revealing. Number one, they found that all the three players had quoted the same price, identical price to the government. So without any understanding, the CCI said, how is it possible that you arrive at the identical price? Second, they found that when it was a tender case, so it was a case where these companies had to submit tenders to the government. So the second thing is that when they went to submit the tenders, they found that actually the same person had made the entries for all three people. So again, the CCI said, unless you three knew each other, how is it possible that the same person makes the entry for all three people? So sometimes circumstantial evidence like this, and then in many other cases, the CCI has even relied on call detail records. So the CCI can call, let's say your mobile number is with Airtel. The CCI will write to Airtel and say, please give me a list of all the calls made during this time. And if it finds that some of the calls were to your competitors, it can use that also as evidence, saying what were you doing, why were you talking to your competitor, what did you discuss about? So one way to do it is to find circumstantial evidence which points to such an arrangement. The second way that the CCI can do this is it has something called a whistleblower policy or a leniency program. So a leniency program is something where, let's say that, you, me and Abhilash, three of us have cartelized. But I realize that, 6 months down the line, I realize that, okay, this is a violation of the law. I might face significant penalties. So what I will do is I will go to the CCI as a whistleblower and say, look, I admit that I was in a cartel. These are the Abhilash and so were the other people in the cartel. And I will give all the details and evidence that I have. I'll cooperate with you. In return, you don't impose a penalty on me. So very often we see that people will go to the CCI as whistleblowers or what we call leniency applicants and disclose the cartel, and they will get off with no penalty. The other parties will get caught. So that is also a method where the CCI uses, where it gets leniency or whistleblower applications. So in that case, you'll actually get direct evidence, because obviously the cartel participant himself will have lots of evidences. He'll have WhatsApp chats, he'll have emails, anything else. He'll say that, okay, I met at so-and-so hotel, here are the hotel bills, etc. So based on that also, the CCI can find the cartel.
Thank you, sir.
Thank you.
Sir, one question, sir.
Yes.
Now, how to prevent the agriculture prices to competitive in this law, sir?
So agriculture so far, sir, unfortunately, the CCI has not looked into, and usually when it comes to agriculture, they should, I agree. Particularly if there is, let's say there is some sort of a syndicate with the middlemen where, I know where you're coming from because I come from a farmer's family myself, so I understand. And I think they can take action. It's just that they've not taken action, particularly if there is a syndicate with the middlemen, the mandis, the wholesalers. When they buy from the farmers, we know sometimes that they coordinate their prices. And the CCI has the power to catch them. It's just that nobody has gone to the CCI and complained so far, I guess.
But here, whistleblower program is here only required.
Absolutely.
Whistleblower agriculture sector. But
Absolutely.
government is not taken any steps for this. Many
I
of the
agree.
farmers are fighting for this. But
I completely agree.
government is not taken any steps. What is the meaning behind this, sir?
Yeah, I don't know. I don't want to venture a guess, but I completely agree that the government should be taking some action.
Yeah,
Okay, thank you, sir.
This is a follow-up question. Since CCI being a union legislation,
Yes.
does it? We are agriculture means state-placed, right? So how does it? Where is the jurisdictions coming in then?
So the Competition Act applies to anybody who carries on an economic activity. So it doesn't depend on the state you are in or where you are. It applies to any person, company, proprietorship, firm, anybody who carries on economic activity. So economic activity means anything to do with trade. So buying, selling goods, anything to do with services, it covers. So that's how it gets jurisdiction over anybody who has economic activity in India.
How are the fines defined? Like, how will CCI come to a conclusion that he should be fined so much? What is the quantum?
Yeah, so the CCI will consider what we call both aggravating and mitigating factors when it comes to a fine. So aggravating factors is, for example, if this is a company that regularly violates competition law, so it's not their first offense. Second, they will also look at how long it took place. If it was a very, very long time, so that means a lot of competition has been affected. Third, it will look at the extent of the market covered, if it was an all India conduct. So these are aggravating factors. Mitigating factors, on the other hand, will be things like, if it's the first time that you are found in offense, if there was no impact on the market. So sometimes that happens because, in a tender scenario, sometimes what happens is you may have cartelized, but ultimately the government authority would have found out and would have cancelled that tender and would have issued a fresh tender. So in that case, technically there is no impact on the market, although you have indulged in unlawful conduct. So it balances out both these factors and then arrives at a number. Should it be 3%, 5%, 7%, whatever.
Okay.
Yeah.
Hello, sir.
Yes.
I have a question.
Yes.
Am I audible, sir?
Yes, you are audible.
Yeah. Actually, sir, my question is related to Bureau of Indian Standard in Hallmark. Hallmark is the agency which certifies the jewelry materials and precious metals, those things.
Yes.
So what they are doing, they have some terms and conditions which is, I think, biased from that side. So
Okay.
what they are doing, they are providing certification but not taking any responsibility. Suppose I'm a jeweler and I'm going for certification of my jewelries, and I said that this is made with 22 carat. In future, maybe some customer will complain that it is falling as not 22 carat, but it is 18 carat.
Right.
In this case, they are holding responsibility of jeweler only. They are not taking their responsibility. Even they have, they are saying that they have tested and certified it. So yeah, so they are charging for certification also, but not taking any responsibility in the stage when any kind of impurity is found.
Right.
Yeah. So in this case, they are the only one player, I can say only one bureau who certifies that jewelries. Yes.
Right.
So is that any breach of, I can say, a competition, because we have only, as a jeweler, I have only one option to go with that bureau, and it is also maybe one or two centers in the entire state. Yeah.
Right.
So as a jeweler, I need to go with my all jewelries to the center and submit for the certification and come back. It is like that. So there are many terms and conditions which is on the benefit of that bureau only. Yeah.
Right.
So what is the possibilities that what we can do in this case?
Right. So I think the first thing we'll have to do here is examine whether BIS or Hallmark, as you say, in giving this certification, is it doing an economic activity? Now, you mentioned that it takes a fee. That means that it is providing a service. So it looks like it can come under competition law. And as you said, if those terms are found to be unfair, that they are not taking responsibility, etc., then perhaps a case for abuse of dominance is made out, particularly because they're the only option. But you will have some question of whether this constitutes an economic activity or not, because sometimes, when government bodies indulge in certification or impose just rules, regulations, the CCI says that merely regulating or merely imposing rules or providing some sort of a certification is not economic activity. But in this case, it seems to be, because you're saying that they charge a fee. So perhaps, yes, there could be, depending on the facts, there could be a case of abuse of dominance.
Okay, sir. Thank you.
So,
yes.
How CCA will handle the repetitive violations?
They will actually impose higher penalties if it is a repeated violation. They will, at a very, very extreme stage, although this power has never been exercised, they in fact even have the power to split up an enterprise. This is in case of abuse of dominance, but if there are several repeated violations, then they can actually say that the company should be split up. But yes, you're right. Repeated violations are generally looked at very, very seriously. And if it's a second or a repeated violation, the penalty will almost always be much higher than the previous time. And there will also be some other consequences.
But only CCI will deal with that.
Yes,
right?
only the CCI. Yes. I think,
And one
yeah.
more thing is, Walmart has been restricted by CCA from entering into small markets, right? So later on, Geo is allowed. Geo, what they did is the same thing what Walmart is supposed to do. So
Uh,
how the
Yeah, well, actually, Walmart hasn't been restricted by the CCI. That's a government decision because they don't want to allow FDI into retail. So that is more a question of government's preference. They don't want to allow foreign players in multi-brand retail right now. In the telecom sector, it's open. So therefore, and of course, Jio is not a foreign-based company; it's an Indian company. So, but that is more of a policy of the government. So that the CCI doesn't have a role per se there.
okay. Thank you, sir.
I think Priya is raising her hand.
Yes, sir. I have two questions. My first question is, when these fines are imposed and collected by the CCI,
Yes.
where does this amount go? Does it go to the treasury, or is it compensated? Is it paid as a compensation to the firms that have, filed a complaint, or is it divided among all the competition players that were affected by this kind of an unlawful activity? This is my first question.
Yes. Okay, first question answer, Priya, is that you're a good question. The fines that are collected go into the consolidated fund of the government of India, so that's not distributed. But separately, for compensation, there is a mechanism under the Act where once the CCI finds a violation, any affected party can go to the NCLAT, which is the appellate authority, and claim compensation. And you have to show that of course, then the regular principles of civil law apply. You have to show that damage has occurred, what is the amount of damages, and then you can claim those damages. So that is separately, and you claim those damages from the company that has infringed the law. So actually, and important point actually, perhaps, and important good that you raised this question. The consequences for a company are not just the penalty. It could also be potentially compensation to the affected parties, which is separate of the penalty. It could be in addition to the penalty.
Okay, sir, thank you. The second question is, in case of repeated offenders, does the CCI also appoint an official to monitor the activities in said firm?
No, it unfortunately doesn't have that much of a power. So its power ends at asking them to cease and desist and imposing penalties.
So there is no check that is put in place for these companies not to commit the offense again?
Well, yes, hopefully the penalty itself should be a check because you don't want to keep paying such penalties every time.
Okay.
But yes, apart from that, it can't interfere in the management and appoint somebody there. But usually
So
what
not
companies...
Not even on a consultation kind of a role or advisory role, it cannot?
What it can do is it can ask the company that you should ensure that there is competition law compliance and therefore you implement a program. So it can order a company to do that.
Okay.
But the company will have to do it on its own. So it will have to appoint some person to be a consultant, etc. The commission can say you should have a compliance program, so that it can, and it has done in the past.
Okay, but this particular thing is not being monitored, right? It would pass the
Yes.
order and say that you need to have a compliance officer, but
Yes.
it need not necessarily follow up and see if that has been done. Or is there some kind of a report that has to be submitted by the company saying that yes, we have adhered to your, or we have put your order in place and we've taken such and such action. This is the person that we've appointed, and this is the new process that we have put in place to make sure that this doesn't happen again. Do they have to report something like this?
The CCI, yes. So in its final order, the CCI can direct that the parties should file a compliance report. So, and if you don't do that, then of course the CCI has powers, it has contempt powers. So if you don't comply with their orders, then there'll be a separate penalty and you can also go to jail for that if you don't comply with their orders. So
Okay,
there's two
so
levels. Yeah.
Okay. Okay, sir, thanks. A follow-up question on the penalty question, penalty aspect. So, if a company is suing this infringing company before the CCI has passed its order or confirmed that yes, indeed, this company has infringed
Yes.
these things, will the suit still be applicable or valid, or do they have, or can they file only after the CCI has provided the guidance or how given the award?
You mean for compensation, right?
Yes, yes.
Yes. So for compensation, it has to be after the CCI's finding, because it's predicated on a finding of violation. So the
Okay,
finding
sir.
of violation has to come from the CCI. Only then can you approach for the compensation.
Okay, sir. Thank you. Thank you very much.
Okay. Santosh is raising his hand.
Yes, sir.
Yeah.
Sir, my question is related to the applicant. I can say informer in this case, reaching to the CCI for the case which is relevant to the mass interest or public interest. So it is something like which is solving some social problem. So
Yes.
what are the rights of informer? Can they claim legal expenses from the CCI, or CCI will cover any kind of expenses occurred to informer in legal process?
Generally, no, because the CCI, because the informer, as you rightly said, is only he's doing it in public interest.
Yes.
So generally in the CCI, they don't order costs to be. In fact, I believe there are no provisions as to costs in the CCI. So generally, as an informer, you don't get. They can't order reimbursement of your legal costs, etc.
Yeah, because in this case, suppose they provide some expenses to the informer, it
Yes.
will only promote people to come for good reasons before the CCI. Yeah,
That's true. That is true. Although, for generally for an individual informant, the filing fee, etc., is very low. So it's not a very significant amount.
yeah, but hiring advocates and
That's
in
true.
this case,
That's true. That
yeah.
is definitely an expense. And yeah, I agree with you. I think there should be something like that, which could perhaps encourage informers to come forward.
Okay.
So then banking frauds. It is come to competition law, sir.
Banking fraud, so fraud per se hasn't. Of course, if the banks cartelize, then that can become, but fraud per se is not a jurisdiction of CCI.
Okay.
Yeah. Actually, on Santosh's previous question, there is a provision for costs. I just checked. So the CCI can order costs to be paid. So you're right. The informer can claim costs, and the CCI could perhaps order the opposite party in case it finds a violation.
Okay, sir. Thank you very much.
So these are civil provision or criminal provisions also there in this case?
Only civil. Only civil.
Only civil.
Criminal is there, but that is in case of non-compliance of orders.
Okay.
We file an execution case for recovery from their assets. In that manner, a criminal case can be executed for issue of warrant. Correct?
Yeah. That's right. That's right.
Okay. Okay.
So, any last questions?
No, sir.
Okay.
Nothing from me, sir. I've missed the first half of the seminar, so I will listen to it again, and if I have questions, I will post it to you, Avinash, sir.
Sure. Thank you, Avinash.
Thanks.
This was like a brunch kind of seminar. We had an information worth so much. We thank you very much, because it's totally new for us, for all of us, including me also.
Yep.
So it's a very blind spot in the practice area of law, where many advocates don't know about competition law. But we thank you very much for enlightening us on this area, and we will invite you more again to speak on any particular topic of competition law, or particular you can discuss a case law also with our students. It would be very informative, educating for all our students. So we thank you once again. So any more comments from any of the students?
Sir, I just got a question, if you don't mind.
Yes,
Avinash
yes.
sir,
Please,
what is the scope of competition law as a career? And I don't know how long you've been in this, but I'm just wondering, how does it look outside, and what kind of capabilities do we need to arm ourselves with if we want to get into this field of law and
Yes.
explore it?
Yes. So I've been practicing competition law for almost 9 years now. So it's what do you need? So the scope is very good because it's still, as you know, as we were discussing, it's still a new law. I think, in my estimation, I don't think there are more than 200 competition lawyers in India, which is very, very less, obviously, in a country of 130 crores of population. So there's scope for a lot more lawyers, and people are constantly looking to hire competition lawyers. In terms of what do you do to get into the field, I suppose just like any other field, you have to show that that you want to specialize in this subject. And how do you do that? You do that by writing papers, by writing papers on this subject, by doing internships in this field, and generally getting yourself more acquainted with this field so that you know when you get recruited, you can show your potential recruiters that you have a special knowledge of this law, which others perhaps don't. And that can happen, as I said, through writing papers, through internships, and if it is available, you know, some sort of a specialized course in competition law, which is there nowadays. Many institutes offer diplomas in competition law. So anything to show that you know you have a special interest in this law.
Priya, I would like to add one more thing. Like Avinash already mentioned, there is avenues for internship at Competition Law Commission in Delhi. And also there is one more branch set up in Chennai. You can try on their website if there are any openings for internship or any write-ups you want to do on competition law. That will add to your CV. So it should be a good start if anybody is looking for competition law. And also if you want to intern under any competition law advocate, you can contact Avinash in future if you have interest. And
So
that will
just
be.
thank you, sir. Follow up on this. Now, if I do have a specialization in competition law, is there any way I can liaise with international firms? Because we see a lot of uh, different countries investing here in India, and we're all employed here. Um, and then we have different kinds of entities that are set up here.
Yes.
So I'm trying to understand if this specialization in this kind of law would also help with understanding or coordinating with competition laws from other countries, or how does it work in terms of this seamless integration between a company originally established in a different country, but who is setting up something in India?
So yes, so I think it definitely helps because the substance of the law will remain the same in almost all the countries. It's just the form and the procedure which will change slightly. You know, the rule against cartels, the rule against abuse of dominance, merger control, that remains the same across all countries. So having a knowledge of competition law in India would certainly help you, as you say, synchronize or even advise foreign clients because the rules will be the same more or less. So that is definitely an added advantage for you when you are dealing with foreign firms or foreign clients.
Okay,
Sir, I think here advocates will know the financial subjects and technicality and law. Three aspects will going in this law, sir.
Yes, yes, absolutely, absolutely.
Avinash
Abhilash,
sir,
you're on mute. You're on mute, Abhilash.
Thank you, Avinash. Anybody has last comments about the seminar?
So diploma course, where it is here, sir? This competition.
I will get back to you. I'll message Abhilash with a list.
Okay, sir.
Excellent,
it was-
excellent section, sir. Very thankful.
Thank you so much. Glad you were all.
Thank you very
Sir,
much.
Yes, sir.
it was
Thank you so much.
wonderful session, sir. It was wonderful session. It
Thank
It's a good
opens
sharing of knowledge.
all new dimension in this field. I think it's very
Thank you.
nice session.
Glad it helped you all, and very, very informed audience, I must say, because the questions were of a very, very high level. We got to discuss topics that I thought I wouldn't be able to touch up because we didn't have time, and I was trying to keep it very basic, but you guys are clearly very, very well enlightened. So glad to have very good interaction. I'm also happy that I learned a lot from you guys. So thank you.
Thank you very much.
Thank you, Avinash.
Thank you.
Thank you, sir.
Bye bye.
Thank you, sir.
Thank you. We'll end the meeting. Thank you, Avinash.
Thank you, Abhilash.
Yeah.
So be safe.